piece. And today we have hopefully a lively conversation with Avril Sharp from Kalayaan and Natalie Sedacca, who's also a lecturer in the law school at the University of Exeter. So Avril is a policy and casework officer at Kalayaan. Kalayaan is an organization working with migrant domestic workers in the UK to improve their rights situation, to help them access the existing rights. And Kalayaan has been very active in fighting the current foreign domestic worker visa, and has been very active in supporting greater rights for victims of abuse in the context of domestic work. Natalie is researching on the human rights aspects of domestic worker legislation in the UK, and she's done a lot of case studies with Kalayaan in the past, and she is about to complete her PhD on this topic at UCL. And we're going to hear from Avril first, and then Natalie is going to talk about the human rights aspects of this issue. So over to Avril.
Hi everyone. Thank you firstly to Exeter for inviting Kalayaan to speak as part of this lecture series. We're a small charity based in London, so we're always keen to be able to speak at events like this to try and raise awareness of the work that we do in trying to improve protections for the particular workforce that we support. So my presentation is going to be on who migrant domestic workers are, a bit about their journey to the UK, and the work of Kalayaan in trying to improve their working conditions. And then Natalie will then speak a bit more about human rights implications, and a little bit of work that Kalayaan has done in coalition with a number of other NGOs in the anti-slavery sector about being denied the right to work and how we are trying to campaign to change that. So I'm going to hopefully share my screen without any technical issues. I can't see how to make it. Wait a second. So. Can everyone see that screen okay? Can someone nod their head? Thank you. Okay, so firstly, who are migrant domestic workers? Well, they're workers first and foremost. They're not coming to the UK on holiday. They're not coming here to see the sights. They're here to work. They often work long hours. They're on their feet all day doing hard physical labour. We're talking about predominantly a female workforce that provides childcare, elderly care, as housekeepers, cooks, gardeners, and security staff. Some consider that domestic work is not real work, and it's often overlooked, undervalued, and considered low skill, which is something that Kalayaan would strongly disagree with. We actually say that it's multi-skilled work and is work that actually allows all other work to happen. And I think the pandemic as well has brought into sharp relief the work done by domestic workers and by other workers on the front line in keeping families and communities across the UK safe. So as you can see from the slide, migrant domestic workers comprise a significant part of a global workforce. The International Labour Organization says that there are currently 67 million domestic workers worldwide, with 1 in every 25 women workers are domestic workers. They often work in informal employment arrangements and are incredibly vulnerable to abuse and exploitation, which is unfortunately what we see a lot of at Kalayaan. Their vulnerability is largely due to structural reasons relating to their dependency on their employer for their work, their accommodation, access to information, and to maintain their immigration status as well, coupled with the fact that this is work that takes place behind closed doors and away from the oversight of any regulatory body. So to start with, I've listed some of the complaints that we see at Kalayaan. This is by all means not an exhaustive list. One of the most common issues is passport retention, which causes huge problems for migrant domestic workers, namely because it contains their visa, so establishes that they have the right to be in the UK, and of course is their identity document as well. Others include excessive working hours, confinement to the workplace, forms of psychological coercion. We also have some reports of physical abuse and sexual abuse as well, but that is, we suspect, underreported because of the nature of it. So at the bottom, you can see a link to our website. Each year, Kalayaan produces reports which we make available, which records the types of abuse that migrant domestic workers experience in the UK. We also break down the rates of abuse according to the visa regime under which they entered the UK. So there are three different visa regimes that are relevant to migrant domestic workers. Firstly, we have what we call the original overseas domestic worker visa. This was introduced in 1998 and was in place until April 2012. This visa was the result of a 10-year campaign by workers themselves with the support of NGOs and the Transport and General Workers Union, which is now known as Unite, in recognition that workers were being abused in large part because they were brought to the UK under a concession which didn't recognise them as workers. So this visa gave workers an independent status from their employers and crucially gave them some basic but fundamental rights. So they're listed on the screen. The most important one is that they had the right to change employer if they were experiencing abuse. This was a right that had some conditions attached to it. You couldn't, you would have to remain working full-time for one employer in their private household as their domestic worker. But crucially, having the right to change employer was a really important safeguard that workers were granted. Also, the fact that workers were able to renew their visa annually, again, they would have to demonstrate that they were still required for their labour. So at the point that their visa was due to expire, they would have to obviously make an application with an employer and demonstrate certain things, including that they'd be paid the national minimum wage. They were also allowed to bring their families to the UK, so their dependent children under 18 and their spouses, and then they could apply to settle and make the UK their home after they had demonstrated with evidence that they had been working in line with the immigration rules for 5 years. So that was the original visa. It's been recognised nationally and internationally as the best form of visa to protect this particular workforce. In 2012, the government made some drastic changes to the terms of the visa, which they said was to restore the visa to its original purpose in being able to facilitate employers wanting to come to the UK and be accompanied by their domestic workers, both of who were coming to the UK on a temporary basis. Now, despite warnings that the changes would institutionalise the abuse of this workforce, the government went ahead and chose to tie workers to their employer and remove their right to change employer for whatever reason. So even in cases of whether it be low level or serious abuse, there was no right to change employer, and the moment you did, you would become undocumented. So we now have a case where at the point people fled their employer, they have been driven underground where they have next to no protection. So in 2016, we had an independent review, which was commissioned by the government. Kalayaan and our partners also campaigned and lobbied for amendments to the Modern Slavery Act in 2015, and as well to the Immigration Act in 2016. As a result of that, the government accepted that workers should have an escape route from abuse and be allowed to change employer, but only whilst their original 6-month visa remains valid. So this right is actually meaningless in practice, given that workers take time to gather courage to leave an employer. They may not speak the language, they may not have a place to stay, which is true in the large majority of cases that Kalayaan sees, and without access to their passport, they have no way of proving their identity or the fact that they have permission to be in the UK, and they don't know how much time they have remaining on their visa either. It's Kalayaan's experience that more often than not, you're talking about weeks. So really difficult for a migrant domestic worker who has experienced abuse to then be able to effectively and safely be able to exercise their right to change employer. So if I go back to the previous slide, actually I'm going to come out of my slides and then try to go to Kalayaan's website. So as I say, we produce annual reports available on our website. If I just take an example here, one of the things that we do is record the types of abuse experienced by workers, and we then break it down according to the visa regime that they came to the UK on. So if I take an example, if I go to psychological abuse, you'll see of the workers that came to see us in 2017 and 2018, 29% of those workers who came under the original visa, 29% experienced psychological abuse. If you then compare that with those who came on the tied visa from 2012 to 2016, again in the same year, the numbers demonstrate that there was quite a significant increase in reported abuse of 59%. And similarly, you'll see that even with those limited changes made after or in 2016, we're still seeing similar, in some cases worse, reported levels of treatment. And if I go to another one, restrictions made on people being allowed to leave the property in which they work. 53% for the original overseas domestic worker visa, compared with 85% and 93% on the more restrictive visa regimes. So if I come back now to the numbers of workers coming to the UK, you'll see here that this provides a breakdown of the nationalities and the countries in which domestic workers are coming to the UK from, as well as their gender. So if we take the most recent year that I've been able to find figures from, you'll see that Filipino women are the overwhelming majority that apply for this visa to come to the UK. And you can also see that the countries that they're applying from, all in the Gulf states, a region which is known for having issues around respect for and upholding rights for migrant workers. So I just wanted to flag a little bit about the application process that workers go through in order to be able to come to the UK. So it's an online application. This represents really the first contact that a worker will have with the UK authorities. In reality, this process is handled by perhaps a personal assistant to the employer, or by an agency that they instruct. So the accounts that we hear at Kalayaan is that workers have little to no control over the application process and know very little about the steps involved or how the process was carried out. often the first that they know about it is when they're taken to a visa application centre to enrol their biometrics. So they have their fingerprints taken and their photograph taken. It's often the case that they don't actually return to that centre to collect their passport. That is either perhaps sent by courier to their employer's address or is collected by someone that isn't the worker. So the UK government has repeatedly said over the years that migrant domestic workers are a vulnerable group and there are safeguards in place to protect them as part of this process to apply for the visa. These safeguards include a requirement that workers be employed abroad for at least 12 months before they come to the UK. The government claims that is to demonstrate that there's a genuine employment relationship there, when in reality, it's more often the case that there has been abuse of labour rights abroad, is generally what is Kalayaan's experience, what we see. Other claimed safeguards are that workers are seen alone, so they should be seen separate from their employer or anyone who takes them to the visa centre, and they should also be given a piece of paper which is referred to as an information sheet in their native language, which sets out their rights as a worker in the UK, and crucially who they can contact if they experience any abuse. So emergency contact numbers are on there, the telephone number for Kalayaan is on there, and a few other contact details for places where people get confidential, independent advice should they experience any issues. I have included a link to a upper tribunal judgment, which is from 2013, to demonstrate that in that particular case, that was a domestic worker from Tanzania who wasn't provided with information as part of the application process, was treated like a slave by her employer. When she was able to escape, she didn't know what rights she had or what support was available to her. So she actually contracted tuberculosis, and there was permanent damage to her lung. So that case from 2013 is demonstrating the risks that are there for workers who are not told of their rights as part of the process, and it's still the case that we're seeing now, even 8 years later. So a little bit about Kalayaan and our work. So we were originally founded as a workers' rights organisation by workers themselves. We remain a small charity of 5 advisors. We're supported by an administrator and an English class teacher as well, who teaches our clients on a Sunday. We support about 100 new clients each year. That is new clients. That doesn't account for those that come back to us each year with a new issue that they need our assistance with. There is no fixed time for the length that we support people. So I've been at Kalayaan 5 years this year, and I'm still working with those that I supported when I first started back in 2016. All 5 advisors are accredited to give immigration advice, which is the main reason why people come to see us, because they're looking to resolve their status and be able to work in order that they can remit money home and take care of children, parents of relatives. We also help to identify potential employment cases, refer these matters to ACAS, and liaise with lawyers to represent them in the employment tribunals. A large part of our work is in identifying and supporting workers that we identify as survivors of trafficking or modern slavery. For some, this is the only route or pathway that they can follow in order to try to regularise their leave in the UK. But even if they do, there is still no guarantee that they'll be granted any form of leave to remain. So we use our frontline experience to inform our policy work and our campaign work to try to improve and demand better protections to prevent the abuse of workers in the UK. So we have a number of campaigns. I wanted to finish up my part of the presentation on our biggest campaign, which is to restore the terms of the original overseas domestic worker visa. earlier this year, we had a parliamentary petition, which was supported by over 12,000 people that supported Kalayaan in the call for rights to be reinstated. I can share the slides after the presentation today. The link will take you through to the government's response, which said that they don't intend for any worker to be subjected to forced labour or abuse or become undocumented, and there is a dedicated process for victims of modern slavery via the UK's national referral mechanism. Their response is disappointing for a number of reasons, mainly because it fails to address the need to prevent abuse from escalating to modern slavery. There is no element of prevention in their response, and does nothing to protect those workers who have suffered abuse of their labour law rights, but perhaps don't meet the legal threshold for a referral into the NRM. So it's Kalayaan's kind of day-to-day experience that we see those workers fall in between that protection gap where there is no support available to them whatsoever. And it's quite a perverse scenario, because at some stage they may well, our genuine concern is that they will become a victim later on in the absence of having any rights whatsoever. So again, there is no element of prevention in the government's response. So I think in Natalie's presentation, she'll touch upon some of the issues to do with the NRM structure, including that a large number of workers aren't able to work whilst they're in this system waiting for formal identification by the state. In Kalayaan's experience, this is a long, difficult process that can take on average about 2 years to conclude. So, we're talking about women predominantly that have experienced real trauma, who are then placed in limbo for a number of years without the right to work, which is obviously why they migrated in the first place. So in response to the government's disappointing response, we have issued a call to action to our supporters. We are asking those who wish to support us to write to your MP and let them know your concerns. So again, on Kalayaan's website, there is a page that sets out the simple steps that you can follow, including template letters that you can use to contact your MP. It would be wonderful if you would let us know of any response you get, whether it be good or bad, so that we can start to build an alliance of MPs standing up for rights for workers. Thank you very much.
Thank you so much, Avril. I think we're going to keep any questions till after Natalie has also spoken, so we can collect all questions together. So I would now hand over to Natalie for her presentation.
Okay, great. Thank you very much. I'm going to share my screen as well. So thank you for having me to speak, and also to Inga for the introduction. So just the only thing to add, apart from being a lecturer, etc., is I'm also a trustee now for Kalayaan. And I'm going to follow on from what Avril said, talk a bit more about the issues facing domestic workers, including for those who are identified as potential victims of modern slavery, and in some ways, as not all of the ways, but some ways that their treatment falls short of human rights standards, and then the right to work more generally. So Avril has explained already what we mean by domestic workers, who they are. So just to give a bit more kind of general background in terms of the framework in the UK, that our labour law framework for domestic workers is weak. So the UK hasn't ratified the International Labour Organisation's convention on this that was agreed, just under 10 years ago. And there are various exemptions. So there's been a potential exemption from the minimum wage for what's called work relating to the family household, which was sort of intended for au pairs on a linguistic or cultural exchange, and has been in some cases applied to domestic workers. There was a recent successful challenge to this in the Employment Tribunal, finding that its application was unlawful and indirectly discriminatory on the grounds of sex, and there's now a consultation on whether that should be scrapped. So it may hopefully change soon, but it's still pretty striking that that has been potentially applied for so long, because that's such a basic right. In addition to this, sort of workers who are classed as domestic servants are excluded from key working time protections like the 48-hour maximum week, and that would apply to other workers. And the private households that employ domestic workers are exempt from labour inspection, so that means abuse often going undetected. Now, the Modern Slavery Act of 2015 provides some measures for victims of what is kind of colloquially known as modern slavery, and that isn't a specific legal term, it's an umbrella term that encompasses human trafficking, actual slavery, which is rarer, and then sort of servitude and forced or compulsory labour. So all quite a high threshold to meet. And so these protections don't apply across the board to domestic workers, kind of echoing what Avril said. It's only those who meet these specific criteria. And even for those who do meet the criteria, the provisions are not adequate for various reasons, which I'll shortly talk about. And this all goes alongside, as Avril has explained in detail, the very harsh visa system. So even after the 2016 changes, the ODW visa is granted for a non-renewable 6-month period. So very difficult for workers to change employers. So if we look then at what happens to those who are identified as victims of modern slavery or human trafficking. So this is really the only exception to the non-renewability of the visa beyond 6 months. So it's where the worker is recognised as a potential victim. And to explain how this system works, there's a process for identifying victims that works through a body called the National Referral Mechanism, and it involves 2 stages. So you first have what's called the reasonable grounds decision. That should be made within 5 working days of a referral. And if that's positive, then the next step is, to have a conclusive grounds decision, and that takes much longer. So although in theory it's sort of from 45 days, as Avril's mentioned, the reality is that it's much longer, often, years, and if not years, then certainly a number of months. And so while they're between these 2 stages, domestic workers are only permitted to work if their initial 6-month visa is still valid at the date of the first reasonable grounds decision. If their visa has expired by that date, they have no right. Sorry, that there's a typo on here that says no right, but they have no right to work pending that decision. So I completed research alongside Avril and Kalayaan. It was published in 2019 in a report called Dignity Not Destitution, and you can see that on Kalayaan's website or the Eventbrite page for this event. And basically what we did for that is interviewed 21 migrant domestic workers that were in between these 2 stages that I mentioned. So they'd received a positive reasonable grounds decision, and they were waiting for a final decision on their status. And of these workers, 11 had permission to work while waiting, and the other 10 didn't. So for the other 10, their 6-month visa, their initial 6-month visa had expired by the date of that decision. And that meant so that, they're completely entitled to remain in the UK waiting, but they have no right to work in that period. So in terms of, just to briefly summarise the main findings, so we found that this way of distinguishing between workers is arbitrary, because the reasons for this kind of delay in getting an initial decision are largely outside their control. So to do with issues like a lack of information about rights and available support, and as Avril mentioned, often not having their passports because their employers take hold of them. And we found a number of negative impacts for those without permission to work. So it caused severe financial difficulties. So individuals have £35 per week government support to live on. Unsurprisingly, that's not enough. And in turn, that means that they're vulnerable to being re-exploited. So we found that some in this situation had taken on irregular work with poor pay and a lack of defined hours. And they also were suffering various forms of emotional distress, which is linked to being unable to send money back to their family members in the Philippines, which is where all these workers were from, which, you know, was their reason for migrating, and which their families were depending on to pay for quite basic things like school costs, medical costs, etc. So the key recommendation in this report is that all migrant domestic workers in the NRM must be granted the right to work, to reduce the risk of exploitation, to let them support themselves and their families, and to help with their recovery. So I'm going to talk a bit about human rights implications. Now, there are lots of different human rights violations around the situation of domestic workers, but for the purpose of today, I'm going to particularly talk about the right to work. It probably isn't as well known as some human rights provisions, so I've put some of the main points about it on the slide, starting with the Universal Declaration of Human Rights, which isn't binding, but it's the kind of foundational document for modern international human rights law. And that states at Article 23 that everyone has the right to work, to free choice of employment, to just and favourable conditions of work, and to protection against unemployment, and also has provisions on kind of equal pay for equal work, etc. And then we've got more detail on that in treaties on economic and social rights, which are binding for the states that ratify them. So at international level, we have the International Covenant on Economic, Social and Cultural Rights, which the UK has ratified, and Articles 6 to 8 cover those points on right to work, as well as other issues like right to rest, leisure, limits to working hours. And we have the associated committee that makes comments on that, which makes it clear that the right to decent work forms an integral part of the right to work. So it's not just a right to be in any work at all, it's a right to a certain standard of work. And then at the European level, we have the European Social Charter. So that's an instrument of the Council of Europe that's also, you know, responsible for the better known European Convention on Human Rights. The UK has ratified its original version. And again, provides for the right to access work, for a worker to earn his living in an occupation freely entered upon, to just conditions of work, safe and healthy working conditions, and fair remuneration. So those are all specific to social and economic rights. They do have slightly more limited enforcement mechanisms, so it is worth looking at, you know, the European Convention on Human Rights. Again, these are just, you know, there's a lot more to this, but these are some points on it. So as may be familiar, the European Convention on Human Rights is mainly a civil and political rights document. It does not have within it an explicit right to work. But the European Court of Human Rights has made relevant findings. So this includes a number of findings where it's seen dismissal or restrictions on work as having a detrimental impact on the right to private and family life under Article 8 of the European Convention on Human Rights. So, for example, an early example is the Sedacca case, which was about restrictions on employment, and the court rejected the state's arguments that Article 8 didn't guarantee a right to retain employment or choose a profession. So they were saying that, you know, issues of work do relate to issues of private life. And then there are various other examples. And a more recent case, which was in the Grand Chamber, was Denisov in Ukraine, and that establishes that where dismissal or disciplinary action has severe consequences on a person's ordinary private life, then it will engage the right to private and family life, and then it will need to be justified based on a test of proportionality. The ECHR, of course, also has a prohibition on slavery, servitude, and forced and compulsory labour at Article 4. And this generates obligations on the state that go beyond just criminalizing and punishing traffickers. So an example is the case Rantsev and Cyprus and Russia, which related to the terms of so-called artiste visas that were obtained by owners of establishments on behalf of workers. And this was fueling exploitation. So in this, the ECHR here, they recognized the harm that this was causing, and they held that states' immigration rules needed to address concerns relating to encouragement, facilitation, or tolerance of trafficking. So it refers to the need for a comprehensive approach that includes measures to prevent trafficking and protect victims, as well as punishing traffickers. So it's that kind of protective approach. So those are some key provisions, and I'll look at how they apply to the situation that we've discussed. So what we've spoken about between us, we can see there are various restrictions on migrant domestic workers' labour market access. So first, because the ODW visa is limited to a 6-month period that's normally non-renewable, so it's very difficult for workers to change jobs in practice. Secondly, it's very difficult to be recognised as a victim of trafficking. Haven't gone into much detail about that, but it is a high threshold, particularly to meet the conclusive ground stage, the second stage. And particularly disturbingly, the government are now talking about actually making that more restrictive in their new immigration plan proposals. Then thirdly, those who are identified as potential victims and are waiting for a final decision don't always have the right to work while waiting. So that's what, the difference I was talking about earlier. And fourth, it's notable that, ODW visas are strictly limited to being a domestic worker in a private household. There's no prospect for workers to change sectors within the labour market to another role. So these measures engage what we can call the negative aspect of the right to work, so basically restrictions on labour market access. And the UN Committee on Economic, Social and Cultural Rights has stated that the right, respecting the right to work by states includes refraining from denying or limiting equal access to decent work for all persons, especially disadvantaged and marginalised individuals and groups. And the groups that they talk about include migrant workers. And they say, the labour market must be open to everyone under the jurisdiction of state parties. So how does the government try and justify these restrictions? So for the difference between workers in the NRM, they seem to suggest that it's about encouraging early reporting of abuse. But this is very questionable because our empirical work, our research, doesn't suggest that workers who leave their employment later are kind of making a conscious choice to delay reporting abuse. But, rather, as we've said, there are lots of factors influencing this that are broadly beyond their control, like a lack of information about their rights, withholding of their passports. So we would say that this is an arbitrary factor, so it's very difficult to justify on kind of human rights principles. Likewise, the broader idea of limiting the ODW visa to just six months. So the idea that if extensions were allowed, this would make workers less likely to report abuse is just very dubious, because the reality is that having secure migration status is a better basis for being able to report. But as Avril also touched on, the broader context for these restrictions is really about the kind of impetus of controlling migration. And the problem here is that it really comes back to treating domestic workers differently on the basis that they are so-called low-skilled migrants, which, as Avril said, we would very much dispute. And the idea that you have the separate set of visa conditions in the sector, which is so short-term without any opportunity for settlement, in contrast with the types of visas you have for kind of high-earning professionalised workers, it really shows how the area of work is devalued, but it's also not compatible with the aim of tackling modern slavery. Likewise, the right to decent work is also part of the right to work, and includes, as I mentioned, these various provisions: just and favourable conditions of work, remuneration, leisure, reasonable limitation of working hours. So what we can see within our study is that the conditions of those survivors of slavery who lack permission to work falls short of this in a number of ways. So where workers were pushed into informal work, this was they had poor conditions, their roles were generally poorly defined, they had irregular hours and lack of kind of defined days off, and they said they would have been reluctant to report abuse, which obviously makes sense in their situation. But the very fact that they are driven into informality is contrary to the UN Committee on Economic, Social and Cultural Rights general comment, which is, states must take measures to reduce work outside the formal economy, because instead the lack of a sort of legal right to work is pushing them towards that kind of informal work. And the situation is then also made worse in the UK by the series of measures called the Hostile Environment, may be familiar to some, essentially based on making life as difficult as possible for migrants that lose their legal right to work or to remain. And for example, this can mean that if you don't have permission to work, that any work you perform could be a criminal offence. So what we really see here is how the lack of protection for survivors of slavery, including the lack of a right to work, can also fuel labour rights violations, so therefore put workers at risk of being subjected to modern slavery again. And also to sort of mention here, the European Committee on Social Rights, which interprets the European Social Charter, has set out requirements for states to adopt and implement specific legal measures to protect domestic workers from forced labour and exploitation. And that includes for inspections of private homes. So again, the lack of a proper protective labour law framework that includes these kinds of enforcement measures can be seen as a root cause of exploitation, which can be up to and including modern slavery. So based on the kind of obligation to tackle forced labour, I would say that the state is, required to change legal frameworks where they facilitate these kinds of systemic violations of the right to work and leave workers vulnerable to exploitation. And that would mean both a better overall labour rights framework and also better protections for survivors of trafficking and modern slavery. So up to now, this has been focused on. We've both been focused on domestic workers, which is what we both focus on. But this final section of the talk it's just going to link it a bit to the broader relevance of these issues, including to survivors of other forms of exploitation. So, in March of this year, Kalayaan released a report jointly with a number of other workers' rights and anti-trafficking organisations, which is about access to work for survivors, which again, you can see the link on the Kalayaan website or on the Eventbrite page for this meeting. And this really reiterates the harmful nature of being denied access to work and how that makes it difficult for survivors to move on with their lives, to integrate socially or feel accepted. And the NRM's delays in making a final decision on trafficking status also means that this applies for a long time. So survivors have to be out of work for long periods, and some would have described that as kind of extending their experience of slavery and impacting negatively on their recovery and resilience. And it also, again, sets out many advantages of allowing survivors to work. So they mirror those in our Dignity Not Destitution report, but also add to them. So by being in work, survivors can gain more structures to their lives. They have a chance to build community links and integrate, strengthen a sense of purpose. Sorry, I just saw a message. I wanted to check it wasn't someone telling me to hurry up. But I am nearly finished anyway. So yeah, and it also allows them to provide for their own needs and those of their dependents, which is really crucial, especially where they need to send remittances, so need to send money back home. So being able to legally access formal work, they're basically less vulnerable to being re-exploited, and they're also less dependent on the state, but allows them to make better use of the support that they do have while waiting for a final decision. So the support worker they would have in that time. So again, the recommendation is you know, all potential victims of slavery or trafficking who are in the NRM should have access to work, and that this should be automatic and not restricted to particular jobs. So again, shows the link between the issues that we're discussing today. So the way that survivors are currently treated, and in particular the limited access to work, is an example of a failure of protection and support and assistance. But along with all the other restrictions on migrants and workers' rights, it's also a root cause of further exploitation, so potentially up to and including modern slavery. So I made the final slide to recap the key points, but I'm not going to, because we're running out of time and I don't want to have no time for questions, I won't go back over them again, but they are there. So yeah, thank you for listening, and I look forward to any questions.
Thank you so much, Natalie. Do we have any questions already? If you can either use the raise your hand feature on the, I think it's on the participant panel, or if you just want to unmute yourself and ask some questions. If we have no volunteers to start with, I have a question, or maybe I have several questions, depending on how this goes. One question that came up for me when Avril was talking, I was wondering, do you have any data on how many workers actually get given these information sheets when they register for the visa? Because I'm wondering like how much of a follow through there is actually with that provision.
We do collect data on that specific issue. Unfortunately, I don't have it to hand, but having worked at Kalayaan now for 5 years, I can probably count on one hand the number of workers who have told me that they have received this sheet of paper. It's literally, I think it's 2 pages of A4. One or two workers have actually presented it to me at a meeting at Kalayaan's offices. So it does demonstrate that it can help, but I think it more demonstrates that the issues with the visa application process remain. We also in 2016 we got a government commitment to have meetings, group meetings for workers once they had arrived in the UK to gain access to information about what their limited rights were and where they could get onward help from. The idea was that it would be a group setting for workers who'd been in the UK for, I think it was in excess of 7 weeks, and it would be run independent of government. So that was a commitment made back in 2016. I have been chasing now for a number of years for an update on that procurement process, which closed, I think, in 2018, so 3 years ago now. And in the last few weeks, we have discovered that there were only 2 organisations that bid. I'm aware of one of them, who would have been very well placed to run the service. They are a migrant-based organisation. They are familiar with the issues that we see at Kalayaan. One of the major concerns that we had with the procurement process is that the scoring, the weight of the scores was geared heavily towards commercial viability as opposed to demonstrable experience working with migrants. So yeah, I'm aware of one of the organisations. I'm not aware of the second organisation, but the response that we now finally have is that the bids didn't meet the requirements. Now I don't know any further than that, and I am keen to work out what that actually means in practice. But it still remains the case that workers are not routinely provided with information as part of the process before arriving in the UK or after. So the situation remains as poor as it has been for a very, very long time now.
Okay, thank you very much. That's unfortunately as unsurprising as it is depressing, but Moving on, so we have a question in the chat on how often are traffickers actually prosecuted, and especially considering the limited support provided by the Modern Slavery Act. Do you have any numbers with respect to traffickers in the context of domestic work? Either of you?
I mean, I don't have any numbers. It's not the side that I mainly look at, but I do know that it's low. I mean, it's Virginia Mantuvalu, who's my supervisor, and was Inga's as well, has written about the Modern Slavery Act 3 years on, and that kind of looks at overall low figures for prosecution. So yeah, it's not like it's working well for prosecutions and not for anything else. That the prosecutions are low, and the other areas of protection are also missing, and that, you know, that is related, as I kind of mentioned, or at least could well be related, because, you know, if you don't have a secure status, it is going to be more difficult to support a prosecution. I suppose there is a bit of a proviso there, because it is a potential route to get discretionary leave to remain if you're supporting the prosecution. So I don't want to be, you know, completely one-sided about it, but I would still say that overall, you know, if you had a more secure means, you know, route to status across the board, it would be likely to increase numbers. At the same time, you know, it's not necessarily the main solution in these areas. Yes, you would need it in the most, you know, it would be important in the most severe cases, but it's also about changing the structural conditions so that there isn't, you know, these violations aren't being fueled.
Okay, thank you very much. Francis, I hope that answers your question. Do we have any other questions? Anyone?
I might jump in if nobody else has one. And I apologise if you said this at the beginning. I was kind of trying to do the participant handling, checking lists and things. But where primarily are your clients based? And I just wondered, I was thinking, you know, specifically about the Southwest, because we kind of wanted to generate some sort of conversations about this as a region, and it's kind of in lots of areas very low on advice and support, and like I guess services tend to be sort of more focused around the Southeast, but I don't know if that's true, and I don't know if you can speak to that at all, or if there are other things that we could do through the university, I guess, that could help, because we have the immigration clinic, and whether there are sort of potential things that we could sort of try and build up a bit for the region. Be interested to hear your thoughts.
So yeah, we are Kalayaan. Our community centre is based in London. I think our experience does tell us that domestic workers do accompany their employers to visit London. We are not blind to the fact that they don't only come to London. So there are, you know, I would like Kalayaan to do some outreach work. We are aware of other areas in which domestic workers do go initially and stay with their employers, and then you know, in the cases when they escape, the kind of communities in which they are supported. So I'm quite keen to do kind of a sort of mapping exercise. Unfortunately, it is, as a small organisation, it is kind of dependent on capacity and resources. But there are, you know, I'm going to give a shout out to a number of other charities that do frontline work in supporting migrant domestic workers. There is the Voice of Domestic Workers. There is FDWA, which is the Filipino Domestic Workers Association. They are both kind of based in London, but I know, especially with the Voice, that they host meetings up and down the country, and I think they're quite keen to develop kind of supported bases across the UK. in answer to your question.
Thank you. I think what you've both said is so interesting, and I'm sort of always very aware, having worked previously in a frontline refugee service, that it's the importance of being able to identify issues and signpost to the correct organisations when things come through, because often people don't know where to go and will just go to sort of somewhere. So that's really helpful. Thank you.
Okay. Sort of last chance for any more questions, if anyone has one. Otherwise, I would have one final question. Natalie, you briefly mentioned that there are sort of parallels to other forms of trafficking and exploitative labor conditions. And I was wondering if there's any sort of push for alliances between different groups of vulnerable workers in fighting for better labor rights, both on a sort of organizational level, but also sort of in general. So, I mean, we see with the sort of classic sectors for human trafficking and exploitation that there are parallels in what the perception of how skilled the labor is and how important the labor is, even though we know that this is untrue, and that there's also a tendency for the kind of sectors that are affected to be, well, have higher percentages of women in some areas, so both domestic work and sex work, and then also have significant numbers of migrant workers, both in the regulated and the irregular workforce, especially in construction and in agriculture. So I was wondering if there are any sort of interesting alliances that could be forged.
Yeah, so I mean, I think it's a really important point, and I guess that the recent sort of joint report that I spoke about is an example of that. I mean, it's specific to survivors rather than across the board, but I think it is important because it's an area where those experiences kind of converge a bit in terms of like being denied the right to work, and Kalayaan has also done some joint work with asylum seekers, on the issue of asylum seekers being denied the right to work as well. I think that Kalayaan is also involved with other kind of coordination efforts. Maybe Avril can add something on that. But yeah, I mean, I think that there's always again, it's sort of with a frontline organisation always kind of limited by capacity a bit, but there's always more that can be done. And obviously the good, in an academic context, it's even more important that we kind of having those conversations about the parallels between these forms of work. Whereas obviously there's some differences and with like your area, sex work obviously faces issues that domestic work doesn't in terms of the kind of criminalization, and domestic work faces issues that other areas don't. But at the same time, there are definitely shared issues that are important to tackle jointly as much as possible.
Great, thank you. Avril, you want to add a little bit?
Yeah, I mean, just to say, I am Kalayaan's campaigns officer. I'm always keen to have conversations with other groups and forge new alliances to see whether there's any kind of common ground, and even not common ground, but other ways in which we can support other marginalised, vulnerable groups of workers trying to, gain certain rights in order that they can be protected at work. An initial thought that springs to mind is we have the seasonal agricultural workers scheme. I know that Flex, which is an amazing charity focused on labour exploitation, recently produced a report, I think last month, about the dangers of that scheme and the fact that it's been expanded 10 times or something ridiculous without an independent review of the scheme, even though it is a sector in which the government recognises that these workers are vulnerable to being abused. So definitely keen to partner up where we can and forge some new kind of shared arguments, you know, for the benefit of all workers across the board, definitely.
Yeah, I think just to briefly add on that, actually, that's because as soon as I finished talking, I was like, I should have mentioned agricultural workers, so it's good that you brought it up. But I think it's such a good example of how, so Kalayaan and, you know, people who work on domestic work have been looking for years at, you know, the problem of this short-term visa and the lack of mobility, and it seemed quite sector specific, but now that exact same thing has come into agricultural work. Why is that? It's, you know, because of Brexit, because previously agricultural workers would come under free movement. Now they can't anymore, and it's kind of, you know, it's labeled as low skill, and they want to do the same, you know, this same kind of way of saying, well, you're just here to, you know, produce value for this country for the amount of time we want you here, and then you have to leave, and then, you know, you can come back maybe in 6 months with a new application. So I mean, yeah, it's just it's a really good example of how these, yeah, we need a kind of a joint position on how all workers, whatever level of pay, etc., you know, should have rights, proper rights to work and rights to renew their visas.
Great, thank you both so much. I think we are not only at the end of our time, we're actually over time. So I would like to thank our speakers, Avril and Natalie, again, and I would like to thank Emma for organizing this series. And I would also like to thank all our listeners and participants for coming to this event and joining us. And if you want to contact Avril, she just put her email in the chat box. So yeah, and if you want to contact Natalie, you can find her information on the University of Exeter's web pages. Thank you all very much and have a lovely evening.